This man spent years provoking people online, baiting anger, antagonizing and humiliating strangers, pushing racial tension to the edge, inciting racial antagonism and fueling tension and conditions for violence, really ultimately to the point where he was confronted for his actions and decided to pull the trigger.
Support freedom of speech. I believe he acted in self-defense.
That's what happened. Chud was assaulted. He defended himself.
Not acting in self-defense? I've watched the videos.
Why you acting like a what? You heard me. Sit down. Keep coming up. I'm gonna mace your ass real quick. I don't want to get pepper sprayed. I really don't. Go pick up my hat. You heard me.
I've seen the posts.
Booga booga. Look how he's tripping out.
I think he was very, very clear about what he intended to do.
Blew his brains out that night. I almost feel like it's knowing to happen.
And I believe...
Was that self-defense or was that the plan all along to pull the trigger? Well, a white live streamer by the name of Chud the Builder is facing decades in prison for his involvement in the of an unarmed Black veteran outside of a Tennessee courthouse. The legal question exploding across the country now is, what is self-defense and when does self-defense stop being self-defense? Can someone provoke violence and then legally hide behind the because this case may test both the First Amendment and self-defense law as we know it. I am Dr. Talia Moore, criminologist, forensic expert, and former law enforcement professional. And today we're unpacking the controversial case of Chud the Builder. So scholars, shall we begin? Dalton Earthley, more commonly known as Chud the Builder, built an online following, really race baiting and, using very controversial language directed at minorities, Black individuals in particular. Prosecutors allege that while outside of a Tennessee courthouse, he took those same antics and that same behavior and incited that same level of violence. However, this time he was met with and confronted by someone who didn't find the humor in his actions at all. And now Chud is reportedly facing almost 60 years potentially behind bars as a result of his involvement in this incident. Some of the charges that he's facing, as I read them: attempted murder, aggravated assault, reckless endangerment, and firearm use during the commission of a felony. So these are some very serious charges that Chud the Builder is currently facing. But here's where things get a little interesting, if you will. Chud is claiming self-defense.
What?
Despite his involvement in the obvious role that he played in provoking the incident, he is claiming self-defense in this case. But let's define self-defense so we have a working understanding of what it is exactly. Self-defense allows someone to use reasonable force in response to a perceived immediate threat against their safety and well-being. If you have the opportunity to leave or flee, then you should take it. Self-defense really applies when there's no alternative but to defend oneself. And so, just kind of give you the definition here and if it applies to Chud in this case. So there's a couple of key words when we think about self-defense. Reasonable force, meaning the force in response to the attack should be reasonable and proportionate to the attack itself. If there is an imminent threat, meaning it is here and now, not somebody down the street or down the road, but if they are right here in your face, that is an imminent threat. And then unlawful harm. Was there going to be harm imposed to you that if you didn't protect yourself that you would be a victim of, right? So we want to make sure that as we're applying this concept of self-defense that it adheres to those expectations. So the danger must be imminent, not hypothetical, not emotional, and not based on fear alone, but based on the gravitas of all of the circumstances together. And then when we think about deadly force, because pulling out a and popping those things off at somebody, right? That is force. So self-defense does not automatically provide protections around that. Self-defense is not automatically valid simply because someone felt threatened. So again, remember that. The law asks who initiated the confrontation. So that will be a question definitely brought to court. Did the person escalate the situation? So who's at fault and responsible for the escalation? Could the person or the people involved safely have withdrawn? Could you leave? If was there a space to leave, a road to leave, and a path to run down? Was that an option? Did they provoke the encounter? And was the response proportionate or proportional to the initial attack? Meaning if you pulled out fists, are we now in a fist fight? If you brought it, are we now in a fight? And if somebody uses was that proportionate to the provocation and then the response itself. Tennessee is considered a stand your ground state, and we've heard about those stand your ground states before, meaning you don't have an expectation or a legal expectation to flee. You can stand to protect yourself. And so again, this becomes the question for Chud the Builder. Is that what he was doing? Was it self-defense and he was just simply standing his ground, or was he provoking a situation that otherwise would not have manifested into a shooting had he not used his traditional and typical tactics of race baiting and anger inciting here? But even without a duty to retreat, juries are still going to examine the ideas around, the use of the weapon here. Whether the threat was imminent, again, whether the response was proportionate, whether force was necessary or the use of it necessary at all, whether the person claiming self-defense provoked the escalation, think about that, and whether a reasonable person would believe that they were in fact in imminent danger if they were in that same situation. Tennessee law does not automatically protect someone who initiated the violence, protects them under self-defense. So the jury in this case will heavily scrutinize some of the factors here. Prior behavior. So I'm sure they're going to run through a whole host of Chud's previous videos, what he has posted in the past, even some of the things that we've seen here today. Was this aggressive conduct? Was he aggressive? Was the shooting victim in this case, were they aggressive? And how did that dynamic manifest? Was there a verbal provocation? Who started it? Who said it? Who walked up to who? And what words were used? And we know that from some of the video that Chud has published before, that he likes to use words to incite racial anger. And so were any of those provocative words used in this case? And whether the shooter, in this case Chud, helped to create a dangerous situation. So the jury will have a lot to review as this case continues to progress, right? Because they'll have all of his prior documented videos, as well as the video from outside of the courthouse. Oh my goodness, we have that available, as well as any additional victim or witness testimony that will be available. So as we look at this legally, let's consider the following. What happens when someone intentionally creates conflict for media content? What happens when rage becomes monetized? And what happens when provocation itself becomes the business model? According to reporting, and my own eyes have seen it too, right? Chud has created a long list and history of these very provocative race baiting videos, right? Racially inflammatory content. And so again, that will be more for the jurors to look at and to consider as they are rendering a decision in this case. Was this an innocent man suddenly forced to defend himself? Or was this someone who was provoking a fight, an incident, and just waiting for an opportunity to pop off on someone? And this was the space and opportunity that he was looking for. Well, we've talked about the First Amendment before, right? Even offensive speech is protected by First Amendment rights. Please check out my video on Afroman for more information on the First Amendment. You can say outrageous things, you can refer to people in videos, but you are not remiss from the consequences that your words may provide. And of course, we would be remiss in America not to include the obvious other layer here, which is race, right? We have a white guy who's speaking to and shooting ultimately a black man here outside of a southern courthouse in the state of Tennessee. Obviously, that's going to add to the conversations being had around the topic here. Would this video and incident be viewed differently if the races were the same? Would we receive this same level of media attention if this was white on white crime? Would the public reaction be different? Would assumptions about fear, responsibility, guilt shift in a different way if the people involved presented differently? Well, these are some real questions. And again, questions that we expect the jury to consider, to ponder, and that we all will probably to continue to think about as this case continues to progress in the court space. So again, this case is bigger than one streamer. This is beyond just the monetization of content, but really the culmination of all of these things. Race in America, right? Race baiting, creating a social media platform that is nothing but race baiting and anger baiting, and then going out and body after laying all of this information and putting all of your views and opinions out there. Well, again, to be determined, but that will become a central issue, as you can imagine, as this case goes to trial. So do you believe that this was legitimate self-defense, or do you think the provocation changes the legal question? That will be discussed. At what point does content creation become reckless endangerment? All right, so speaking about First Amendment, again, check out the Afroman video here.
Want more with Dr. Moore, the criminologist of the Bay? Follow us on Facebook at Want More, Instagram at Want More Dr. Moore. Be sure to comment, like, share, and subscribe. Until next time, educate, empower, and enact the changes you want to see. Want more.